Okay, so we go through the appeal process and we don't get what we think is a fair value for a property owner, or not the value at least that we're after, and it's a ways away, right? What are our other options are there other options?
Yeah, so after you do your appraisal review board hearing, if you don't get the value that evidence dictates or you don't get the value you think you ought to get, there are a couple other options you can do, one of which is, like you said, binding arbitration. And what happens there is the state appoints a third-party arbitrator to hear the case again. We present our evidence to them, the appraisal district presents their evidence, and they'll make the final determination on what the value for the year ought to be. It's going to be a final. There's no recourse after that. Basically, that's the final value for the year. We try to be pretty selective, with which properties we take to binding arbitration, because there's some fees associated.
So it's got to make sense.
Yeah, that's right. It's got to make sense for the value difference to be basically safe. If it's an extra $5,000 in taxable value, that's never going to net you enough to lose the case, right, because of those fees associated. The way it works is you have to put down a deposit at the beginning when you file, and at the lowest end, that's $450. And it goes up from there depending on the property and the exact particulars of the case. If you don't have a homestead exemption, it's automatically higher. If your property is over a certain value threshold, it's a multiple basically. So we try to be really careful about which properties we recommend going to binding arbitration. Okay. Because what we want to do is provide enough space for us to lose the hearing and you still, recover your deposit. The way that the hearing works is the arbitrator is going to determine between our evidence. He's going to pick a value. Sometimes it might be exactly our value, or it might be exactly the appraisal district's value, or it might be some random value he makes up in between. And if that value is $1 closer to the appraisal district's value than our value, if he splits the difference exactly but is $1 closer to their value, we technically lose the hearing. And while the value was reduced, you forfeit your deposit. If he's $1 closer to our value, you get $400 of those $450 back, basically. They keep a $50 filing, processing fee or whatever.
We're pretty strategic with how we're doing these.
That's right.
Okay.
We want to make sure that we can win, and want to make sure that we can win by a margin where even if the value is reduced and we don't get that deposit back, you're not out that $450.
So more money in the client's pocket.
That's right.
I'd say about 95% of the arbitrations we take on any given year, we are reaching out to the property owner and saying, we think this is a good case. Those other 5% are the property owners coming to us and saying, I'm not happy with it. And we're going to weigh the options with them, whether it makes sense or not, and really decide if this is worth it. You may end up losing money because you were emotional about your value, and we don't want the property owner to do that.
Right. So that's arbitration, and then that's pretty much anything under $5 million. We're gonna arbitrate, and then a lot of the higher value stuff we do with, like the apartments and the retail and multifamily, that's gonna be stuff over $5 million, and then the option there is litigation or a lawsuit. If you can go over what that is.
Yeah, we call it litigation. It's an appeal to the district court. It is only for property values that are non-homestead exempt over $5 million. And that it does become more expensive than arbitration. There is no deposit that you could receive back. It is a straight filing fee, attorney's fees, and then potentially if the case has to go to a trial, you're going to talk about trial fees, you're going to talk about witness and expert reports. So it is a little bit more cost prohibitive, to say the least. But that is the option for our big commercial properties that we represent. Anyone with a value, like I said, over $5 million, it makes sense to look at that. It is not for bluffing, I will say. You need to have a good case, because just because you're shelling out this money for the litigation filing fee doesn't mean the county is just going to give you the value that you're looking for. So the evidence has to make sense. We're going to weigh it with the cost savings, and in the end make sure that the value that we're targeting makes sense, and that the amount of savings you're going to get if we even got to that target value makes sense for the property owner. It's a lot more time intensive as well, I'll say. Just like any lawsuit, there's going to be courts involved. There's going to be motions involved. There's going to be discovery evidence passed back and forth. And all of that takes a lot of time. So if you're expecting to file litigation and be done and get a lower value and be done in like 6 months, even after your ARB hearing, it's probably unlikely that that's going to be the case. It's
we don't
probably more
set
likely a
those
year
expectations.
later.
Yeah, we've had some that have taken 2-3 years. So let's talk about what happens in that case, right? If you have the deadline to file your, or excuse me, the deadline to pay your property tax bill is January 31st of the following year, right?
Right.
So if you've got a litigation ongoing for 18 months after that, how is that handled?
There are options. As your property tax consultant, we're going to advise you every single time just to pay the higher amount on your property tax bill. So that is another thing that you need to consider, is you're going to have to pay the higher amount. It makes sense to do it because you will get a refund check after the case is resolved if there's a reduction in value. The other option potentially is you just pay the undisputed amount of your property taxes.
So the county will, or the tax assessor will issue a refund once it's all settled. So essentially, they're gonna have to pay that amount up front, but then a couple months later, they might get a refund check in the mail for that amount, that discrepancy between the value that we have.
Could be a couple months. It could be 6 months later. Anytime a hearing that goes to litigation like this is resolved, it typically takes, on the low end, 10 weeks for it to process and for a refund check to be sent out to you. On the higher end, it could take 3, 4, 5 months.
They do always send it out, though. I do have some clients that are like, what if they don't send me the check? What if they don't refund? The tax assessor issues the refund.
Yeah, they have to issue a refund, and if they don't do it in a certain amount of time, they actually have to include interest now.
No.
So it's
Good investment.
it makes sense for the tax assessor to get that processed as soon as they can.